ordinance making power is something, let's say, which is an important topic, and it has various types of facets, different types of its dimensions. And 2 times they have asked question in recent times on re-promulgation. This they have asked 2 times. This ordinance question has been asked, but re-promulgation has become important, and they have asked 2 times. Let's say. So this is what we have to understand. This. So let's talk basics one by one. This. So first, if you take about law making. Lawmaking. The lawmaking is power of legislature. Yes. Lawmaking is power of legislature. Legislature is, that is how there is idea of separation of powers. So this, it is based on separation of powers. That legislature executive and judicial. This. So it is to make law. It is to execute law. It is to adjudicate law. Yes. But let's say the parliament, if you take Indian parliament is, let's say, it works through sessions. It works through sessions. Sessions can be like, let's say, as of now, so we may have monsoon session, let's say. So we have budget session, monsoon session, and winter session. You'll find that there are gaps. This, we have, let's say, almost 2 months gap. There can be gaps, let's say 2 months, 3 months gap, let's say this. So when there are gaps, and during that time, suppose a need has arisen that there should be a law, so what should be done? What executive will do? It will face challenge. This. So it will face challenge. This challenge in the sense, if you take like this, so this, and suppose there is a need, urgent need for law. So when there is urgent need for law, so we cannot call parliament. Means we cannot call the session of parliament. This. So there should be a temporary arrangement. If we are able to make here urgent need for law, if we are able to make a temporary arrangement, if we make a temporary arrangement, right, that temporary arrangement is, this power is given to executive. The temporary arrangement means that if we suppose we give power to executive to make law, right, and that law will be for that temporary duration. Yes. So when we give such power to make law, so this we say as ordinance. This we say as ordinance. So ordinance is something, power has been delegated. Can we say? It is like law making power. This legislature is trying to delegate power to executive. It is a power delegation. Right. It is a power which is being delegated to executive, and that is how, let's say that ordinance, it is a delegated power to make law for temporary duration. This, and if it wants to become a permanent law, then what can happen is it depends on parliament that after 2-3 months whatever parliament comes into session, so it can approve that law. If it approves that law, it will become a law like any other law. If it does not approve, so that life will end. So ordinance is a sort of temporary legislation by executive. You can say ordinance is a temporary legislation by executive. This you can consider. And it was done because our parliament is not always in session and there can be urgent need to make law. And with this intention, this is how framers of the constitution included provision for ordinance in the constitution. Right? So this happens. So let's write on this few lines, right? Ordinance can be considered as a temporary legislation by executive, to overcome any vacuum created due to Parliament not being in session, and there is urgent need for law. Yes. Ordinance, let's say, ordinance is a delegated power of legislation. Ordinance is a delegated power of legislation given to executive by legislature. This. So this can be considered. Now, constitutional provisions. Constitutional provisions. Yes. So, constitutional provisions. What are constitutional provisions? So, Article 123, and we have Article 213. Okay. So, let's write under Article 123. President is empowered in bracket governor under Article 213 to proclaim or promulgate, ordinance on the advice of Council of Ministers. On the advice of Council of Ministers. When Parliament is not in session, and there is urgent need for law, That's rationale behind ordinance. A subtopic, rationale behind ordinance. Since Parliament functions through sessions, there can be possibility that a time has arisen that executive needs law to meet the urgent situation. Right. And hence, to meet the urgent situation, and hence, Parliament has delegated this role to executive. Change paragraph. Unlike legislatures in US, UK, Australia, Canada, where legislature functions throughout year. Legislature functions throughout year. Legislature functions throughout year. In case of India, legislature functions through sessions. Hence, this provision was made in Indian Constitution. Right? So, basically we are talking about ordinance. Ordinance, as we have told this, and so yes.
So,
what are the urgent needs? Yes, we'll tell that urgent needs. Let me first tell that in case of US, UK, Australia, Canada, they don't have ordinance system. This is true. We are only major democracy which has ordinance system. This our country has. So we are only major democracy which has this kind of ordinance system first. Now, why there should be ordinance, as we told that their parliament means their legislature हमारे जैसा नहीं है. उनका legislature 2 घंटे के लिए काम करता है और रेगुलर बेसिस पे काम करता है. So it is not like in case of our legislature, it starts in morning, ends in evening, and without business, only walkouts. Yes, they don't have that much time. So they will just, their session is for 2 hours, their session is for 3 hours. If they have any business, they will do that business, and then house is, let's say that means house ends, let's say. Then they focus on their work. Then next day also it can meet, next day also. They regularly, there is no session concept. They have regular meetings. So when they have regular meetings, there is no vacuum created. So when no vacuum created, so there is no need to delegate law-making power to executive. But in our country, there are sessions. And sessions, let's say, there can be delay. This is how the condition is that there should not be more than 6 months gap between 2 sessions of legislature. It means that there can be a maximum 6 months gap between 2 sessions. So when there are 6 months gap, generally 2 to 3 months gap we have. So if you see budget session, monsoon session, winter session, you'll find generally 2 to 3 months gap. In that, if there is any urgent need to make law, then what executive should do? Now it is, your question is very valid. What is that urgent need? This. So let's take that urgent need. Let's say COVID crisis. Halaki it is a crisis-like situation. So when COVID crisis comes, Parliament is not in session. What executive should do? And it needs law. It can be one such. बट इसको भी आप काउंटर कर सकते हो कि कोविड तो सारे देश में आया था, तो उन्होंने लॉ कैसे बनाया? राइट, तो उनका पार्लियामेंट फंक्शन किया, हमारा पार्लियामेंट नहीं फंक्शन किया. उस क्राइसिस में भी यूएस कांग्रेस, यूके पार्लियामेंट, ऑस्ट्रेलियन पार्लियामेंट, दे केप्ट फंक्शनिंग. राइट, हमारा ही ये हुआ कि उनको तो एक्सक्यूज मिल गया, दिस इज हाउ इट इज, दे डिड नॉट फंक्शन. राइट, तो यू कैन से दिस. Right now, let's say कि urgent needs की time to time it may arise. It can be related to financial matter. It can be related to health. It can be related to education, or any, let's say कि law and order. Let's say like I will give you recent example. Right. The recent example is, let's say, NCT Delhi case, 2023. This 2023, and Supreme Court gives a judgment. Supreme Court gives a judgment that the public service in Delhi should come under control of Delhi government. Right? Now, Center Supreme Court passes judgment. It passes a judgment, right? Judgment. But center does not agree, suppose. The center does not agree. Center does not agree. Now what you should do? Only a law, by law it can nullify Supreme Court judgment. Center many होता है जैसे शाहबानो केस. तो शाहबानो केस, राजीव गांधी did not agree with Supreme Court judgment, so he brought a law, criminal law amendment. Similarly, government urgent define नहीं है. What is urgent? Situation will define. It is not defined. First. Second is that urgent, just recent case we are trying to show you, that the Supreme Court passes a judgment which center does not agree. Now center wants to nullify the judgment of Supreme Court, and Parliament is not in session. Parliament is not in session. what it should do? Right? It introduce ordinance. That is called Public Service Bill. It introduced ordinance. And when Parliament came to session, so it was approved. This is urgent. This. So that is how we can consider. There can be urgent situation, and then the executive may need to issue ordinance. This. And because of that, let's say that this rationale, this is the rationale, let's say. The problem is not at that level. Problem is not at the level ki whether executive should have ordinance power or not. That was even recognized by the framers of the constitution. So when framers of the constitution have included ordinance provision, the problem is not ki we have to think should we have ordinance power at all. That is not a debate. Right. So need for ordinance has been recognized by the court also. Court has also not nullified ordinance per se, rather its misuse. Right? This. So that is how we can consider about what rationale we can say. The COVID crisis, this we can consider as example, and we are trying to deal. This is how constitutional provision, since we are coming late, and we were trying to make people understand what is ordinance. Ordinance kya hai, law making kya hai. This. So this basic thing I told, very basic thing you should know about this. The ordinance is also a law made by executive, right? This.
So then what was the rationale behind having a session type of thing rather than throughout the year in India system?
Yes, because let's say that ki MPs, etc., they should also get time. This, ours is a huge country, diverse country, transportation system, many other factors. Let's say there it is a small country. The small country is that, so मान लो suppose frequently you come here, MPs frequently come to Delhi, that will be very costly. Then they go back. Someone is coming from Northeast, someone is coming from Kerala, and UK Parliament and overall, let's say the mobility system, if you say, this. That way, let's say, already before that also session system was already introduced. It's suiting to our, let's say, the overall demographic system and let's say ecological aspect, that can be considered. Like this. Now, the process is simple. What is the process of proclamation of ordinance? The process is that ki Council of Ministers gives advice to President, and President proclaims it. Then it is published in Gazetteer of India. Means it is notified. The law is notified. That will happen. Then advantages, let's say, advantages of ordinance. Advantages of ordinance. Right. First, it helps in dealing with any urgent situation. Dealing with any urgent situation. Right. Next, it helps in overcoming. It helps in overcoming vacuum in lawmaking. Vacuum in lawmaking. Next, it brings flexibility. It brings flexibility. Flexibility. Next, it eliminates dilatory process of lawmaking. Dilatory process of lawmaking. Next, executive has law implementation experience. Executive has law implementation experience. Yes. Change paragraph. The main advantage is to overcome any emerging challenge. To overcome any emerging challenge, as it is the executive which is responsible for enforcement of law, enforcement of law. Like COVID crisis, and some ordinances which were proclaimed. That's it. Scope of ordinance. A subheading, scope of ordinance. First, ordinance is equal to any law made by legislature. It has the same legality and force. As law made by legislature. Next, it can amend law, abolish law. However, let's change by however, it has following limitations. First, by ordinance, Constitution cannot be amended. Next, it can remain in force maximum 6 months plus 6 weeks. It can remain in force maximum 6 months plus 6 weeks if it is not approved by Parliament. Note, when ordinance is issued, it should be introduced in Parliament when it comes into session. If it is not introduced for approval, its life ends automatically. After completion of 6 months plus 6 weeks. Next, if it is introduced for approval, then it will go through the same process. It will go to the same process as any bill is introduced. As any bill is introduced. Any bill is introduced, right? So let's take one, what some technicality basic things we are talking. So we have told that scope kya hai? What is the scope of any ordinance? The scope is equal to any law made by legislature. This. So any ordinance is equal to, any ordinance is equal to, it is equal to law made by legislature. It will have the same force, it will have everything what a law can have. This, the ordinance is also equal to a law made by legislature. This now. Next thing we are saying is that now legislature. It means ki a law can, when you make ordinance, the ordinance can be also introduced to abolish law. This, the abolished law, you can, let's say, amend law, or you can have create the new law. Either you can abolish it, you can amend it, or you can create a new law. This, but limitation क्या है? Limitation ये है कि that it cannot amend constitution. So constitution cannot be amended. This, because it is an ordinary law, ordinary bill. The ordinance will be an ordinary bill, you can say that. This ordinary type you can consider. Ordinance is an ordinary type, let's say. It is not a constitutional amendment bill. So ordinance will be like ordinary type of, let's say, legislation. This you can say this. Which one, once you introduce, then you can categorize. It is money bill, finance bill, or ordinary bill. But in general, ordinance is an ordinary law. But constitution is amended only by constitutional amendment bill. This. So that way, let's say, it cannot amend constitution. This, it cannot amend constitution. This is a limitation. This, plus let's say now 6 months plus 6 weeks. This, now before 6 months and 6 weeks, because session comes, house, let's say, comes into session. So when house comes into session, so either you seek its approval, you will seek its approval. So once you seek approval, now thereafter the process of bill will govern. Isn't it? If you seek approval, so it will be similar to what? It is like now any bill. Right. It will go through the process of bill. Now let's say that it can be rejected also. It can be approved also, it can be rejected also. It depends on that parliament. Right. Suppose you do not seek approval. We do not seek approval, then what happens? It ends. This, do not seek approval, तो इतने दिन तक वो कंटिन्यू रहेगा. वो बीच में गवर्नमेंट विड्रॉ कर सकती है. Ordinance can be withdrawn by the government before completion of 6 months, 6 weeks. Can we say this? President can withdraw it. The way you have issued, you can withdraw also. This, or if you do not want to withdraw, so it may remain into effect for 6 months and 6 weeks. And thereafter it will automatically end. Right? Right. No. It is not discretionary power. Right. How it will be discretionary power? Why it is not discretionary power? Why it is not discretionary power? This, it is not discretionary power, right? क्यों? देखो डिस्क्रिशनरी पावर क्या है? लेट्स टेक इट, अगर इसको हटाते हैं, डिस्क्रिशनरी पावर क्या है? डिस्क्रिशन का मतलब क्या होता है? राइट, फ्री टू एक्ट. दिस डिस्क्रिशन का मतलब दूसरा होता है सेल्फ इनिशिएटिव. दिस फ्री टू एक्ट. दिस इट इज अप टू योर डिस्क्रेशन बोलते हैं ना, इट इज अप टू योर डिस्क्रेशन, ये आपके ऊपर है, राइट? तो क्या ये प्रेसिडेंट के ऊपर है? ऑर्डिनेंस इज नॉट अप टू प्रेसिडेंट, राइट? yesterday we told you, तो लेट्स से कि बिल, नाउ लेट्स टेक दैट कि काउंसिल ऑफ मिनिस्टर्स गिव्स एडवाइस to president, right? Now up to him whether he will accept or he will return, isn't it? It is up to president ki he will accept the advice or he will return the advice. It is a discretion. This, now second thing we told that after election no party gets a clear majority. You have different permutation combination. Which combination you will invite? It is up to president. Which party to invite to form government? It depends on his calculation. One day that time will come, we will talk also this. This you can say this. It is discretion. And third thing we told, let's say government has lost its confidence and more than 6 months tenure is left, then in that case what will happen? It is again his discretion. This is how discretionary power, right? So यहाँ पे discretion नहीं है. Ordinance या कोई भी power है तो यहाँ पे discretion नहीं है. Ordinance, पहला discretion क्या है? He has to proclaim on the advice of, क्योंकि ये मेंशन नहीं है लॉ में तो आपको इसीलिए yesterday I told that कि since everything is done in the name of president, तो those who do not understand polity in parliamentary democracy, they will think that कि president is acting. But wherever it is written कि president can proclaim, president can pardon, there president has to act on the advice of council of ministers first. Now condition क्या है कि पार्लियामेंट शुड बी इन रिसेस. रिसेस एक लैंग्वेज होता है कि पार्लियामेंट इज नॉट इन सेशन. पार्लियामेंट शुड बी इन रिसेस. आइदर हाउस इज नॉट इन सेशन, द पार्लियामेंट इज नॉट इन सेशन टू अप्रूव इट. तो दिस इज ए कंडीशन. यस, एंड देन मेयरली दिस एंड दिस नॉट. सिचुएशन शुड बी अर्जेंट. और ये सारा टेक्निकलिटी भी नहीं अप्लाई करो आप. सिंपल, प्रेसिडेंट लॉ नहीं बना सकते. लॉ तो इम्प्लीमेंट गवर्नमेंट को करना है, तो प्रेसिडेंट कैसे लॉ बना सकता है? गेटिंग? अल्टीमेटली लॉ हैज टू बी इम्प्लीमेंटेड बाय गवर्नमेंट, वेदर गवर्नमेंट नीड्स दैट लॉ. एंड प्रेसिडेंट के पास वो है नहीं सारा सेक्रेटेरिएट वगैरह लॉ ड्राफ्ट करने के लिए. Anyhow, let's come to our technicality. What we were talking is this is how the basic things, let's say that basic things related abolish etc., seeking approval, not approval, but these are not needed when you write your answers. These are very basic thing about ordinance. Answer will go beyond that. Anyhow, then we have to talk that issues and problems. This issues, problems, this you can consider. criticisms, whatever you can say this. Okay. And that will also have disadvantages. Right. So, let's write on this. First, ordinance has been proclaimed even if situation is not urgent. Next, it has been done even to bypass legislature. Next, too many ordinances have been proclaimed. In bracket, more than 500 ordinances since 1952. Next, ordinances have been even re-promulgated for over 14 years. 14 years. Next, arbitrary arbitrariness in ordinances. Therefore, ordinances, since they have been misused, they have posed following problems. They have posed following problems and challenges. First, breach of separation of power. Breach of separation of power. Next, usurpation of legislative power. By executive. This bypassing of legislature. Bypassing of legislature. This threat to constitutionalism. And rule of law. This राइट ये सारे इंटर रिलेटेड टर्म्स है, लेकिन एग्ज़ाम में क्या होता है, टर्म्स मैटर करता है. दिस तो आपको क्या करना है, फटाफट ये सारे टर्म लिख देना है. So these are very heavy and key terms, let's say that, this which we will just explain that कि कैसे ये होता है, right? So misuse होता है, so you know that कि ordinance has been misused like anything, right? This सो जैसे मिसयूज फर्स्ट लेट से कि जैसे लेट मी टॉक कि मिसयूज कैसे हुआ है. मिसयूज, तो यू नो दैट कि 1969 बैंक नेशनलाइजेशन. बैंक नेशनलाइजेशन, आपको पता है 14 बैंक्स वर नेशनलाइज. Such a huge law, why you are doing by ordinance? Is it so urgent? बैंक नेशनलाइजेशन तो 6 महीने के बाद भी हो सकता है. राइट, ऐसा तो कुछ होने वाला नहीं है. Bank nationalization you can do even let's session 2 months gap you have, 3 months gap you have, let the session comes, then you should. And such a huge decision you have, bank nationalization, nationalizing, let's say making all those private banks as public bank, 14 such banks, it is a very important legislation. So what you should do, you should wait for the legislation, means legislature to come to session, but it was not done. Then let's say that called Bihar broke all records. So Bihar has a case of 259 ordinances. Right? 259 ordinances, of which over 70 ordinances were re-promulgated for 14 years. Can you imagine? For 14 years. Yes. Over 69, 70 such law. What they did, when house comes into session, they do not seek approval. And when the house ends, they proclaim it. When again house comes into session, they do not seek approval. House ends, they proclaim it. Not 1, 2, 3, but over 70 such. Not 1 year, 2 year, 3 year, but 14 years. 14 years. और ये पता कैसे चला? तो कोई टीचर, there was any teacher who was studying something. So when he was studying, तो then he came across this practice. कहीं पे कुछ literature मिला होगा ऐसा कुछ. तो he thought like ये तो अजीब बात है. And then petition was filed in the court. Yes. So you know this, how misuse happens like this. Still it does not, it does not matter, let's say. Right. So from there it comes re-promulgation. From there it comes re-promulgation. This because some of them were re-promulgated for 14 years. This. Now let's take recent example. Recent examples. Right? The recent example, you know that in 2012, around Nirbhaya incident when happens, there is the criminal law amendment. Amendment ordinance was introduced. And session was just left 17 days. How many days were left? After 17 days, session was going to start. Nirbhaya incident criminal law, if you amend, urgency क्या है? वैसे भी जो perpetrators थे, they cannot be punished retrospectively. With criminal law, you cannot apply retrospectively. तो जो उनको punishment दिया जाएगा, as per whatever the criminal law existed that time. Anyway, amendment will not bring any change. And only 17 days are left. So you wait, but why you are bringing? If you bring ordinance, so it will satisfy public mood. This. So you are trying to play with public sentiment, you know this. And लोगों को ये सब पता नहीं है. लोगों को तो लगेगा भाई law amend हो गया. This. दैट इज हाउ विल फाइंड दिस. जस्ट टू नो, इतना सारा फैक्ट्स आप नहीं लिख पाओगे, आंसर्स में ये सब फैक्ट्स नहीं लिख पाओगे, ये सब मेंशन कर सकते हैं. देन व्हेन लेट्स से कि 2014 गवर्नमेंट कम्स टू पावर, न्यू पार्टी कम्स टू पावर. नाउ दे इंट्रोड्यूस वन ट्राई अमेंडमेंट बिल. One ordinance, try amendment, right? Now, when it comes to power, तो वैसे भी गवर्नमेंट इज फॉर्म इन मई एंड जून. जुलाई अगस्त में सेशन आ जाएगा, मानसून सेशन. बस. So you should, when session will come, so you should introduce that, right? And ये भी किसके लिए? तो गवर्नमेंट का खाता जो खुला था, मतलब दिस इज हाउ. So government opened its accounts by ordinance. It was a majority government. The first law made by BJP party, means government, was an ordinance. वो भी किसके लिए था? Try. So basically Nipendra Mishra, you know that. So Nripendra Mishra. So he was head of TRI and he retired. In TRI law, TRI Act, it was mentioned, anyone who becomes member or chairperson of TRI after retirement for 6 years, he should not join or take any government employment. Right? And government had to appoint Nripendra Mishra principal secretary. कल बात कर रहे थे हम लोग प्रिंसिपल सेक्रेटरी एंड कैबिनेट सेक्रेटरी की. देखो प्रिंसिपल सेक्रेटरी कितना इंपॉर्टेंट होता है. गवर्नमेंट वांटेड टू अपॉइंट नृपेंद्र मिश्रा एज प्रिंसिपल सेक्रेटरी, बट ही इज बार्ड फॉर 6 years एंड ही कंप्लीटेड ओनली 4 years ऑफ रिटायरमेंट. तो गवर्नमेंट ने क्या किया? गवर्नमेंट इंट्रोड्यूस अमेंडमेंट एंड मेंशन 4 years फ्रॉम 6 years. Right. 6 years was reduced to 4 years. कि any, let's say, member or chairperson who, let's say, retires, so he should not become take up any government employment for 4 years. And he was made eligible by ordinance. Was it urgent? And it is a law amendment for one person. लॉ अमेंडमेंट फॉर 1 person. वाई? कल को अगर कोई 3 साल कंप्लीट किया होगा टर्म तो लॉ अमेंड कर देंगे. इट इज नॉट अर्जेंट. बट मैटर वहीं तक नहीं रुकता है. राइट. रीप्रोमल्गेशन. फिर से इशू आता है रिप्रोमल्गेशन का. राइट. एंड इट इज अबाउट न्यू लैंड एक्विजिशन लॉ. न्यू लैंड एक्विजिशन. राइट. लैंड एक्विजिशन बिल. It was re-promulgated 4 times. This. प्लस फिर से आता है बिहार. फिर से केस बिहार का आता है रीप्रोमल्गेशन का. दैट विल टेक व्हेन विल टेक केस लॉज. राइट. मीन्स जैसे सुप्रीम कोर्ट ने बोला है कि बुलडोजर नहीं चलाना है, भाई चल रहा है. राइट. उसी तरह से सुप्रीम कोर्ट ने बहुत सारे केसेस में बोला है कि आपको ऐसे नहीं करना है. बट व्हाट दे आर डूइंग? दे आर नॉट लर्निंग. दे आर जस्ट स्मॉल किड्स, इजंट इट? जैसे बच्चे नहीं लर्न करते हैं तो पेरेंट्स बोलते हैं ना कि तुम लर्न नहीं करते, अपने मिस्टेक से लर्न नहीं करते. तो गवर्नमेंट कभी मिस्टेक से लर्न नहीं करती है. दिस एनी हाउ. तो बिहार का केस है, वी विल टॉक इट. एंड दिस लैंड एक्विजिशन, so there have been re-promulgations also. The re-promulgations are there, ordinances are there, and let's say that misuse has not stopped, even if we have case laws. Supreme Court has several such case laws, but we have not. Then how they pose challenge? How they pose challenge if you have such misuse? Right. So suppose a law which was supposed to be made by legislature and you are making, basically you are usurping its power. Right. आप उसका power छीन रहे हो. So a law which is not urgent, and if executive is making that law, so this is how it is like we have written. So we can talk here criminal law amendment bill 2012 we can say. It can be considered as usurpation of power. आप उसका power ले रहे हो this, and it is breach of separation of power because executive does not have law making power. Law making power goes to legislature. It is breach of separation of power. Now, this is act of bypassing legislature, and this will threaten constitutionalism and rule of law because you can do by ordinances some excesses. You will obstruct the rights of people, you will affect the public interest. That way, let's say that it threat to constitutionalism. Constitutionalism is called, let's say that constitutionalism is the idea of rule of law and limited government. A government should work in limited fashion, but यहाँ तो maximum fashion, let's say that. If it is working. So that you have to understand that ordinances means simple, let's understand that you do not have law making power, but you are making power since you can make power. Right. It is like I will make power, जो बिगाड़ना है बिगाड़ लो. Basically this is how it. तो आप ऐसी की तैसी कर रहे हो आप पूरे system of let's say constitutional governance. So we say it as a constitutional governance. That is how it is threat to constitutionalism, rule of law. क्यों? आप बोलोगे कि पार्लियामेंट को तो अप्रूव करना है, अगर नहीं अप्रूव लॉ आर्बिट्रेरी है तो रिजेक्ट कर दो, और 6 months का हम क्या करेंगे? Parliament will reject the law after 6 months and 6 weeks. Suppose already excesses have been done. Already arbitrariness, let's say you have implemented arbitrarily. And many a time it happens. When you have implemented a law, the parliament also, let's say, thinks that since law has been implemented, that they may not reject it. This is how you have to understand. So, government, because ordinance is made by bureaucracy. One more, let's say, point, let's say that this lack of democratic scrutiny. There will be lack of democratic scrutiny. What is lack of democratic scrutiny? When law is made by legislature, it goes through the process. So there are debate and discussions. The debate and discussions, people will know, people will become aware, they also participate, media also becomes aware. But when a law is made through ordinance, you may not know, even you may not notice it. Because it is made by government and then it is implemented. But when a law is made by parliament, so when they will teach you or you should know that, what Wilson said, when parliament through session means parliament is on exhibition, and parliament through committees means parliament at work. The parliament is on exhibition. Exhibition means democratic education, democratic awareness. This happens. It will be open. When a law is made by legislature, it is open to all. But when a law is made by government, it is not open to all. The flaws in the law will remain. because committees also scrutinize law. When law is introduced to parliament, then it goes to committees that they scrutinize. Because of that we can consider. So that is how ordinance, when it is not urgent need, it is not considered appropriate, rather it is called, this is how, executive democracy, marginalization of parliament, it is one example. Right? It is one example of marginalization of parliament. This, that is what, let's just summarize this. The misuse of ordinance shows that rise of cabinet system has brought marginalization of parliament, that it undermines parliamentary democracy. Parliamentary democracy. There are many occasions when ordinance has been issued without urgent needs, even re-promulgation, re-promulgations, which are the clear case of arbitrary lawmaking by executive. That's why time to time, this misuse of powers, has been scrutinized by judiciary. So you should know that this .1, 7.6. This is the average, let's say that ordinance issued, right? That during 50s we have less number of ordinances. Yes, and 2000 this decline, but 90s we have high, let's say, incidence of ordinance. This let's say even concerns have been raised against ordinances, like first by G.V. Maulankar. First speaker, in a letter written to Prime Minister Nehru, in a letter written to Prime Minister Nehru, देखो वो एक टाइम होता था जब स्पीकर्स बोला करते थे, तो उनको अप्रीहेंशन था मावलंकर साहब को कि हो सकता है गवर्नमेंट ऑर्डिनेंस लाएगी, तो ही रोट ए लेटर टू प्राइम मिनिस्टर कि ऑर्डिनेंसेस जनरली शुड बी अवॉइडेड. तो ही रोट रिप्लाई टू स्पीकर, he says do not worry, government will not bring ordinances unless it is urgently needed. This next, President Pranab Mukherjee, next, President Pranab Mukherjee raised his concerns related to re-promulgation of new land acquisition bill by saying that government did not have only legal responsibility but also moral responsibility. Government did not have only legal responsibility but also moral responsibility. Moral responsibility. Moral responsibility. Right? This the misuse has also been characterized. The misuse has also been characterized by Ordinance Raj. Ordinance Raj or governance by ordinance. Governance by ordinance, which started during 1970s. Right? So these are some cases related to misuse. Now we'll take case laws. So let's say case laws. Case laws. So basically first time it happened, we have this called R.C. Cooper case. (1970). Then we have D.C. Wadhwa case. This. Then we have 2017 Krishna Kumar case. This. These are three major cases. This. There are other cases, but they are small. Let's say these are three major cases. This we have to see this, right? So for the first time it happened. Let's say before this case, you should know that Article 123. Let's say that. So it is presumed that judiciary does not have a scope of judicial review of proclamation of ordinance. Generally, it was presumed that a court cannot review presidential order. That's why they say petitions were not filed. You'll find this. Gradually, let's say people started becoming active and thinking. That is how R.C. Cooper case comes. It is related to bank nationalization. When bank was nationalized 1969, it was challenged, and that challenge is known as R.C. Cooper case. And in this R.C. Cooper case, this is how court says that you cannot have an act of bypassing legislature and ordinance is subject to judicial review. This, so let's write on this. R.C. Cooper was first major case in which ordinance was challenged. It was generally presumed that ordinance was outside the purview of judicial review. Outside the purview of judicial review. Outside the purview of judicial review. Judicial review. Right. In this case, Supreme Court gave following views. First, ordinance cannot be used for bypassing legislature. Ordinance cannot be used for bypassing legislature. Next, judiciary has power of judicial review. Judiciary has power of judicial review. Power of judicial review. This. Next, let's say DC Wadhwa case. DC Wadhwa case. It was related to 259 ordinances. It was related to 259 ordinances of Bihar. And it is most landmark judgment. It is most landmark judgment on ordinance, which is still basis for reviewing misuse of ordinances. The court stated first, ordinance was subject to judicial review. Next, the court could strike an ordinance. The court could strike an ordinance if it was arbitrary. Next, it should be issued only when there was urgent need. Next, re-promulgation with the same text of law. Re-promulgation with the same text of law was unconstitutional. Right? Try to understand. इसी से केस बनता है, क्वेश्चन आता है, तो that is how we have to talk about this. Right? So what it says, that फर्स्ट टाइम देखो, पहली बार कोर्ट काफ़ी क्लियर होता है. अभी तक कोर्ट क्या था, सबमिसिव होता था. अब कोर्ट बिल्कुल असर्टिव हो गया, बोलते हैं कि वी कैन स्ट्राइक ए लॉ ऑल्सो. दिस कूपर केस में उन्होंने नहीं बोला. In RC Cooper case, they do not say that we can strike a law. But in DC Wadhwa case say कि if a law which is arbitrary issued by ordinance, if the law can be struck, the judiciary can strike the law. This. So that it told. Plus it also expresses its concern related to re-promulgation part. And it says that if you are re-promulgating and the law has the same text, there is no any change in text of law. It is violation of constitution, because you are just doing nothing but bypassing legislature. This, so that is how it's judgment, right? However, it did not say that re-promulgation was not allowed. It does not make re-promulgation completely unlawful, right? It does not make, again I will, it does not make re-promulgation unlawful, right? And that is called Wadhwa exception. It will take a bit later. This is called Wadhwa exception. We say it as Wadhwa exception. This, what is Wadhwa exception, we will talk later. Now let's take Krishna Kumar case. So फिर Krishna Kumar case. It was again related to re-promulgation. It was again related to re-promulgation of ordinance of the same state, Bihar. Same state, Bihar. In this judgment, Supreme Court very assertively told, Supreme Court very assertively told that a re-promulgation was a fraud on Constitution. A fraud on Constitution. However, it did not make re-promulgation. It did not make re-promulgation completely unlawful. Completely unlawful. Completely unlawful. I guess it is 21, not 17. It is 2021. It is not 17, 2021. Right. अब ये समझना है कि उन्होंने क्यों नहीं ऐसा किया. Why they have not made it completely unlawful? This re-promulgation. This, and what safeguards we can have against ordinances. This, that we have to understand. So this, let's say that re-promulgation. First, let's say that when we take re-promulgation, let's say that why re-promulgation has not been. why re-promulgation has not been made completely unlawful. Completely unlawful. Yes. Why re-promulgation has not been made completely unlawful. This. Right. Try to understand that. Suppose re-promulgation. Why there is need for re-promulgation? What is re-promulgation? Suppose there is legislature, and this legislature has issued ordinance. It has issued ordinance. Now, it comes into session. The House comes into session. But session, let's say, due to lack of paucity of time, there can be possibility. This is how the logic is given. Due to paucity of time, this legislature may not be able to, let's say, give approval. It may not consider. Right. It can have huge, let's say, pending business. Because of pending business. Because of pending business, this means paucity of time or pending business, the House may not be able to consider that ordinance and it may not pass. Hence, the House is forced to, the House is not approving. When it is not approving, the government is forced to re-promulgate. There can be this urgent situation. That is how one logic is given. This second logic is given, let's say, called COVID crisis. COVID crisis. But this logic was given by Wadhwa Exception. This Wadhwa, let's say. That's why he did not make re-promulgation completely unlawful. This one. This is called Wadhwa Exception. It raised its concern. It says that re-promulgation with the same text of law is unconstitutional. But at the same time, it does not say very clearly re-promulgation is unconstitutional. It should have told any re-promulgation is unconstitutional. But it does not say any re-promulgation is unconstitutional. Right? This is first technicality you have to understand. Since Wadhwa case did not say any re-promulgation is unconstitutional, and in Krishna Kumar case, Supreme Court says that re-promulgation is a fraud on constitution, still it does not say also re-promulgation is unconstitutional. Why? It is a 7-bench judgment and Wadhwa is a 9-judge bench judgment. So a 7-judge bench judgment cannot make 9-judge bench judgment unlawful. This is there is limitation, right? And that's how re-promulgation has survived. Right? This is how re-promulgation has survived. This was the question. You have to write answer in 2022. तो क्या बच्चों के पास इतना क्लैरिटी है? Do they have this clarity? This is a challenge.
लक्ष्मीकांत ने बस मेंशन किया केसेस के बारे में.
Lakshmikant will not help you. Mains के लिए Lakshmikant it is not going to help. Right? Yes. This is called Wadhwa exception, which we have to means tell it ki why it is. Now, do you think this logic is tenable? Means it is a good logic? No. Pending business to extend the session.
और फिर ऑर्डिनेंस तो अर्जेंट इश्यूज के लिए होता है तो सबसे पहले उसी को काम करना है।
Yes. If it is pending, तो आप भाई और बढ़ा दो, एक दिन बढ़ा दो, क्या प्रॉब्लम है? Session of Parliament can be extended by 1 day, 2 days, not a problem. This logic was given by the petitioner, but court did not accept this logic. There is a case here, Gyanendra Kumar case. While dictating, I will tell. A case, किसी ने फाइल किया था petition कि वाधवा exception should be done away with. The court did not agree on that. Basically, court did not want to go into. कई बार वो नहीं चाहते हैं जाना मैटर में, right? This now again, let's say that crisis, yes, COVID crisis makes sense. This so court will perhaps not make re-promulgation absolutely unlawful, because there can be such a situation where legislature may not be able to approve, like say COVID crisis type situation. But then you need to minimize the scope of re-promulgation. That is also you have to understand. That is how there is a gray area. Gray area is that the court cannot clearly define how to make law, what should be the content of law, what is the intent of law. They have their limitations, and that's why we need constitutional morality. That's why we need constitutional morality, because there are legal gaps. The legal gaps demand that those who are ruling the country, they have constitutional morality, means they respect law, they respect constitution. This is called constitutional morality. The constitutional morality is about respect to law, respect to constitution, respect to constitutional governance. Unless you have respect to constitutional governance, no judicial intervention and anything can stop misuse of powers. So biggest or best check on misuse is called constitutional morality. This you can say, which will write in safeguards, right? So let's write on this. Right. Re-promulgation. Re-promulgation is related to ordinance, which Parliament may not approve due to paucity of time. And hence re-promulgation was not made in Wadhwa case, completely unlawful. In Wadhwa case, completely unlawful. Completely unlawful. It is known as Wadhwa exception. It is known as Wadhwa exception. Exception. Okay. This exception was challenged, which is known as Gyanendra Kumar case. But Supreme Court in that case did not pay serious attention did not pay serious attention. Rather, it justified Wadhwa judgment. It justified Wadhwa judgment. Wadhwa judgment. This matter has again been debated, and it was argued that in Krishna Kumar case, the Supreme Court would pass a clear judgment, but it did not. Although it remarked repromulgation was fraud on Constitution. Repromulgation was fraud on Constitution. Fraud on Constitution. Then, can repromulgation be made unconstitutional? Can repromulgation be made unconstitutional? It cannot be made because of legal challenges. It cannot be made because of legal challenges. Legal challenges like first, what is urgent cannot be defined. What is urgent cannot be defined. Next, the court cannot look into the intent of law. The court cannot look into the intent of law. That is, in Venkat case, in Venkat Reddy case, Supreme Court remarked that the court could not look into the intent of lawmaking. Next, there can be urgent situation. Like COVID crisis, in which an ordinance may not be approved. Or Parliament may have pending business which may result into non-approval of ordinance. It means gray areas of misuse of ordinance remain. That's why That's why constitutional morality becomes important. That's why constitutional morality becomes important. Constitutional morality becomes important. This. So this we can say that why it becomes important, right? Now, so let's say safeguards against misuse of ordinances. Safeguard against misuse of ordinances. First, speaker and leader of opposition should play statesman type of role. In bracket, G.V. Maulankar. Next, Parliament should function for over 130 days. In bracket, National Commission to review the working of Constitution. It recommended for this. Next. Supreme Court case laws, especially DC Wadhwa case and Krishna Kumar case, should work as guide for proclamation of ordinance. Next, constitutional morality. Morality should be encouraged. In bracket, NCT Delhi case 2018, Deepak Mishra stated that constitutional morality was second basic structure doctrine. Second basic structure doctrine. And next, separation of powers should be respected. In bracket, Keswanand Bharti case. Basic structure was, separation of power was basic structure. Separation of power was basic structure. Yes. Next, last. It's change in paragraph, enough to write points. B.R. Ambedkar remarked remark that ordinance should be issued only when there was urgent necessity. There was urgent necessity. It is important to maintain rule of law and promote constitutionalism. India adopted idea of responsible government. Hence, it should be respected and followed in letter and spirit. This is the best note on your ordinance. You should know that. बिल्कुल perfect है ये. आपको इससे ज़्यादा जानना नहीं है. Everything is mentioned, case, this, that, facts, all these things, right? And then you should be able to write your answer. This when it is asked, right? So I guess you will be able to answer those questions that we have written in beginning. Oh. Yes. Average, yes. Percentage average. It's average. Right? And it can be drawn. You can draw in. That's whether ordinance is a legislative power or executive power. Legislative power. यहाँ हेडिंग एग्जीक्यूटिव पावर है. हेडिंग इज एग्जीक्यूटिव पावर बट इट इज ए लेजिस्लेटिव पावर. सुप्रीम कोर्ट ने क्लैरिफाई किया इसको. द सेम वेंकट रेड्डी केस. तो ऑर्डिनेंस इज ए लेजिस्लेटिव पावर. क्यों? ये लेजिस्लेटिव पावर है जो डेलीगेट किया है ना. तो एग्जीक्यूटिव पावर कैसे हुआ? It is exercising, but it is a legislative power. It is a power of legislature that has been given.
But it is also not parallel. It is not parallel to the parliament.
Right. It is not parallel to the parliament. That, but that's why it is not parallel, because when legislature, if it is executive powers, it will become parallel. Both institutions, if it is executive power, it can also exercise. Legislature can also exercise. Right. But it's not that executive has law-making power. In case of conflict between both, legislative power will override executive power. It's not like that. Since it is a legislative power, that is how it is subject to the same process and procedures and scrutiny. Yes. And since it is a legislative power, that's why in Venkat Reddy case, court says the court cannot look into intent of ordinance. Because the way court cannot look into intent of law making of parliament, right? So similarly, it cannot look into this intent. It is a legislative power. Technically, it is a legislative power. This you should know that. Then it cannot question the intent. The intent of ordinance cannot be questioned. Substance can be questioned. What you write in law, that can be questioned. But intent behind that, you cannot question. Right? So that's why gray areas will remain. Yes. That is how you should know. It is just for more clarity we are talking. Yes. Do they have separation of power? Yes, yes, got it, got it, got it. Ordinance. Whether we have this, do ordinance wala question? Do you have this analysis wala set? Question analysis? Because I want to give you that question to write. Or I'm not able to. Where they gave it. Separation of powers. Got discussions. We are updating, and because we'll include 2024 question also, then you'll get it. This question analysis like this. So this was the question in 2022. This called this. Discuss the essential conditions for exercise of legislative powers by governor. तो ये गवर्नर का फर्स्ट पार्ट है. First part is related to governor, which we have not taught you. This you should know that. Then discuss the legality of, this is how it is. This part you write, ये छोड़ दो आप. Discuss the legality of re-promulgation of ordinances by governor without placing them before legislature. Yes, the second part you write, forget about first part. बहुत ही टेक्निकल, कभी कभी वो क्वेश्चन इतना टेक्निकल पूछते हैं, बिल्कुल शार्प नॉलेज चाहिए उसके लिए. यस, वेग नॉलेज से काम नहीं चलेगा. Yes, prior, it is during I think 1980 around it. This, it is before Wadhwa case. It is before Wadhwa case. Between R.C. Cooper and Wadhwa case, Venkat Reddy case comes. Yes. So you write this answer, we'll see how what you write, legality wala. This. Have you written coalition wala question? Right. You submit it. I have not seen it. I will see it. I was occupied basically till yesterday, although still I have continued because of that is mains examination, optional. So now copies etc. all evaluated. So free, I am free now. Yes. So I will check it, I will see. Tomorrow we will discuss, give the feedback. Right? And you write on this. Because now we have decided that every day we will give you one question. Every day one question for your practice. This. Then there was another question on ordinance. This, but there are three questions. One question I am missing somehow because there was another question on re-promulgation that came in 2017 around. Because there was a story behind that question.
So what level should be 250?
This, yes, 250, 15 mark question. Yes, anyhow, there is another question. This. So, it is a very big question. ऐसे इतने बड़े-बड़े question भी आते हैं. Right. Yes. So, reporting to ordinances has always raised concern on violation of spirit of separation of powers. तो ये तो first समझ में आता है. You know this. Right now. While noting the rationales justifying the power to promulgate, rationales that we have told, the rationales, this promulgate ordinances, analyze whether decisions of Supreme Court on the issue have further facilitated resorting to this power. This is how we are saying they are not clearly stated. Wadhwa exception, Gyanendra Kumar case, and now you know that again Krishna Kumar case. They are not very clearly stating this. So that is how you have to mention those cases. The cases you can mention. This, should the power to promulgate ordinance be repealed? Yes. Yes. So safeguards, rather there should be safeguards. So you write this question also. Two questions. तो this question का भी आंसर लिखो तो बिल्कुल reinforce हो जाएगा. Right. It means 2022, 24 में आया नहीं, तो 25 में possibility है आने का.